The night my mother read my name off the updated will, crossed out, gone, like I had never existed, I did not cry at the table, I did not argue. I picked up my water glass, set it down quietly, and left before dessert was served. What my parents did not know was that 3 days later, a man named Arthur Wren would call me from a number I didn't recognize. He had been waiting 13 years to make that call. What they did not know was that everything they thought they had taken from me had already been placed, quietly, legally, irrevocably, in my name. Their cruelty that Thanksgiving didn't cut me out of anything. It simply started the clock. Before I continue, tell me where you're watching from in the comments below. And hit like and subscribe if you have ever been written off by the very people who were supposed to protect you. My full name is Emily Parker, and I grew up in a house that looked like everything from the outside. 4 bedrooms, 3 floors, a circular driveway that my father had repaved every 5 years because appearances mattered more than almost anything else in our family. We lived on Aldermore Lane in Greenwich, Connecticut, in a neighborhood where the hedges were always trimmed and the Christmas lights went up the first weekend of November without exception. From the street, we looked like the kind of family that had it figured out. The kind of family other people pointed to. Inside was a different story. There were 2 sets of rules in our house, and I understood them by the time I was 7. Not because anyone sat me down and explained them. Children don't need things explained. They watch, they absorb, they know. My brother Colton was 3 years older than me, and he was what my mother called her firstborn miracle. She said it without irony. Usually at dinner parties, usually while Colton sat beside her, looking modest in the practiced way he had perfected. He was tall, early, athletic, without much effort, and he had my father's jaw and my mother's ability to make a room feel like it existed for him. Teachers liked him. Neighbors remembered his name. When he broke the kitchen window with a baseball at age 11, my father laughed and called it a sign of good arm strength. I was not Colton. I was quieter, more likely to be found reading in the window seat of the upstairs hallway than playing outside. I asked too many questions at the wrong moments. I was interested in things my parents found impractical: history, law, the fine print on the documents my father occasionally left on his desk. My mother used to say I had a difficult personality, and the way she said it made clear she did not mean difficult as a compliment. The rule for Colton was simple: succeed and be celebrated. His grades were posted on the refrigerator. His trophies lined the shelf in the living room my mother called the formal sitting area, and we were not allowed to eat in. When he got into Dartmouth, my father rented out the private dining room at the country club and invited 40 people. The rule for me was different: exist quietly and don't ask for more than you're given. When I got into UConn on a partial scholarship, my mother said, "That's fine, Emily," and went back to her phone call. I don't say this to make you feel sorry for me. I say it so you understand the geography of the house I grew up in, who stood in the light and who learned to navigate by the edges of it. The one exception was my grandfather. Gerald Parker was my father's father, and he was the kind of man who took up space in a room not by being loud but by being entirely, unhurriedly himself. He was 71 when I was born and still sharp at 83 when he died. He had built the original Parker family money in commercial real estate in the 1960s and 1970s, long before Greenwich became what it became. And he had the particular confidence of a man who had made things with his hands before he ever made them with money. He used to pick me up from school on Fridays, when I was small, just the 2 of us, and we would stop at a diner on Route 1 that my mother considered beneath the family. He ordered black coffee and pie and let me talk without interrupting, which was not something I experienced very often at home. He saw me. That's the simplest way I can say it. In a house where I was mostly managed, he saw me. He had a habit of saying things quietly that only made sense later. When I was about 8 years old, sitting across from him in that booth with a grilled cheese I hadn't finished, he looked at me over his coffee cup and said, "Emily, the things that matter most are never kept where people think to look." I nodded like I understood. I didn't, not then. I filed it away the way children file things away, in some unnamed drawer that only opens years later, when the key finally fits. He died the November I turned 16. Pancreatic cancer, diagnosed in September, gone by the following spring, except that it happened faster than the doctors predicted, and he was gone before the leaves were fully down. I was not told how serious it was until near the end, which I have come to understand was a decision made by my parents, not by him. At the funeral, My mother wore black and received condolences with the practiced grace of a woman who understood the social value of grief. My father gave a short eulogy that focused mostly on Gerald's business acumen. Colton shook hands with the right people. I sat in the third pew and said nothing, and felt the specific weight of losing the one person in that family who had actually been paying attention. His will, as far as our family knew, was straightforward. The bulk of the Parker estate, the primary investments, the Greenwich property portfolio, the accounts, passed to my father. A few charitable bequests, some pieces of furniture designated for specific relatives. Nothing for Emily. Or so everyone believed. Nobody mentioned a trust, nobody mentioned Arthur Wren, and my grandfather, careful, quiet, deliberate man that he was, had counted on exactly that. The Thanksgiving I turned 19, my mother set the table with the good china. That was the first sign something was planned. The good china, the Wedgwood set she had inherited from her own mother and kept behind glass in the dining room cabinet, only came out for occasions she considered significant. Easter. Christmas Eve. The dinner party she threw the year my father made partner at his firm. It was not a casual meal china. It was a This Matters china, and seeing it on the table when I came downstairs that morning told me, before a single word was spoken, that the evening had been arranged around something specific. There were 8 of us. My parents at either end of the long mahogany table. Colton and his girlfriend, Alyssa, who had the particular quality of agreeing with everything my mother said while appearing to form her own opinions. My father's younger brother, Uncle Dean, and his wife Carol, who drove up from Westport every Thanksgiving and left early every year without fail. And me, seated where I was always seated, middle of the left side, between Carol and an empty chair that had been my grandfather's until 3 years prior and that no one had officially reassigned. Dinner was normal on the surface. Turkey carved by my father with the electric knife he brought out once a year. Sweet potatoes with the marshmallow topping that Colton liked and I had never understood. Carol's contribution of a cranberry relish that no one touched, but everyone complimented. The usual choreography of a family that had practiced performing togetherness long enough that it mostly passed. It was after the plates were cleared, before dessert, that my mother set a cream-colored envelope on the table in front of her. She did not make a dramatic gesture of it. That was the thing about my mother. Her cruelties were always delivered with perfect composure, as though she were simply managing a household matter that happened to involve you. "Before Loretta brings out the pie," she said, and her voice was the pleasant, carrying voice she used at charity luncheons, "your father and I want to share something with the family." Colton glanced at Alyssa. My father straightened slightly. Dean and Carol exchanged a look I couldn't read. My mother opened the envelope and removed 2 folded sheets of paper. "We've updated our estate documents," she said. "We felt it was important for the family to have clarity." No surprises down the road. She unfolded the first sheet. I recognized it even from across the table. The formatting of a legal document, double-spaced, with the letterhead of a law firm in Stamford I had seen on correspondence in my father's study. She began to read. She read slowly and clearly, the way she read aloud at the annual Christmas Eve service she organized at our church. With the measured pace of someone who understood that the words mattered less than the performance of delivering them. She outlined the primary bequest to my father's existing holdings, the Greenwich property to be maintained in trust for Colton, the investment accounts, the summer rental on the vineyard, the contents of the house. And then she reached the section concerning the children, to our son Colton Richard Parker. She read, "We leave the entirety of the remaining estate." She paused there. A half-second. Long enough to be intentional. Emily has been removed from the document. This reflects our belief that she has not demonstrated the values or the direction that would make stewardship of this family's legacy appropriate. The table was quiet, not the quiet of shock exactly, more the quiet of people who had been told in advance and were now watching to see how I would respond. Carol's fork was very still on the tablecloth. Dean was looking at the centerpiece. Alyssa was looking at Colton, who was looking at his water glass with an expression I could not quite name. Not guilt, not satisfaction, something more complicated and less honest than either. My mother refolded the papers. "We wanted you to hear it from us directly," she said. Rather than be surprised later, I looked at her. I had a lot of things I could have said. I had been composing versions of those things, in some part of my mind, for most of my life. Responses to the thousand small dismissals, the rewritten rules, The moving targets, the years of being managed and minimized by people who called it love. I had the words. I had probably always had the words. I picked up my water glass and took a slow sip. I set it back down on the Wedgwood placemat, exactly where it had been. I folded my napkin, cloth, not paper because of the good china, and placed it beside my plate. I pushed my chair back and stood. "Thank you for dinner," I said, and I walked out of the dining room, through the front hall, out the front door, and into the November dark without my coat. I sat in my car in the driveway for 4 minutes. I know it was 4 minutes because I watched the clock on the dashboard because I needed something concrete to focus on. It was 34 degrees. My breath fogged the windshield. Then I started the car and drove to the motel on Post Road, where I had, without telling anyone, already reserved a room for the night. I had known, in the way you sometimes know things before they happen, that I might need it. I did not cry until I was inside with the door locked, and even then it was brief. Not the long grief of someone blindsided, but the shorter, sharper release of someone who had half expected the blow and still felt it land. I was 19 years old. I had $2, 300 in a checking account, a car with 80,000 miles on it, and a partial scholarship to a state university. I had nothing from the Parkers, or so I believed. 3 days later, on the Monday after Thanksgiving, I was in my dorm room when my phone rang. Unknown number, Connecticut area code. I almost didn't pick up. I almost let it go to voicemail. I was sitting cross-legged on my dorm room bed, with a contracts textbook open in my lap. I'd switched my major 3 weeks earlier, from general studies to pre-law, a decision I had not announced to my parents and did not intend to, and my phone was buzzing on the pillow beside me with an unknown Connecticut number, and I almost ignored it, the way I ignored most things that felt uncertain that week. Something made me pick up. "Emily Parker?" The voice was older, measured, the kind of voice that had spent decades in rooms where precision mattered. "Yes," I said. "My name is Arthur Wren. I'm a notary and estate administrator based in New Haven. I was a colleague of your grandfather's for many years." Gerald Parker, a brief pause. "I'm sorry to contact you out of the blue. I want you to know this call is entirely appropriate. I've been waiting for the right time, and I believe that time may be approaching. But I'm not able to say more by phone. I'd like to meet with you in person, at your convenience, when you feel ready." I sat very still. "Is this about his estate?" I asked. "It's about something adjacent to his estate," Arthur said carefully. "Something that was handled separately. I want to be precise with you, Miss Parker, because I think precision is what you deserve. I can't give you details today, but I want you to know, nothing has been lost, nothing has expired, and you have time." He gave me his office address in New Haven. He said there was no urgency, that I could call whenever I was ready, that he would be there. Then he wished me a good evening and hung up. I sat with the phone in my hand for a long time after that. I did not call my parents. I did not call Colton. I did not tell anyone. Not my roommate, not the one friend from high school I still spoke to regularly. I wrote Arthur Wren's name and number on a notacard in my careful block handwriting and tucked it into the inner zipper pocket of my backpack, where I kept the things I didn't want to lose. And then I made a decision. Not about Arthur Wren. I wasn't ready for that yet. I made a decision about myself. I had walked out of that dining room on Thanksgiving with nothing except my own name and whatever I could build with it. My parents had made very clear what they thought that was worth. I had a choice about whether to accept their valuation. I chose not to. The next morning I woke up at 5:45, which was earlier than I had been waking, and I made a list. Not an emotional list, not what I wanted to say to my mother or what I wished had been different, a practical list. What I had, what I needed, what I was going to do. I had a scholarship. I had my job at the university library, 12 hours a week at $11.50 an hour. I had $2,300 and a car, and the ability to read a lease agreement carefully before signing one, which I had already done once, and planned to do better next time. What I needed was to stop waiting for the Parkers to assign me a value and start determining my own. I found a room in a house 3 miles from campus. $400 a month, shared kitchen, quiet landlord who didn't ask questions. I moved in the first week of December with 2 trips in my car. I sent my parents a text that said I had found housing and I was fine. My mother replied, "Okay." My father did not reply at all. Colton sent a voice note 2 weeks later. He said he hoped I wasn't being dramatic. He said Mom and Dad had made a reasonable decision, and I should try to understand it from their perspective. He said family was family, and maybe after some time I'd come around. I listened to it once. I did not respond. What I did instead was study. I had always been a good student in the quiet, unspectacular way that doesn't get you praised at country club dinners. Not top of the class in a way anyone noticed, but thorough, careful, the kind of student who read the footnotes and remembered them 6 months later. Pre-law suited me in a way nothing before it had. I understood instinctively that the law was a language, and that fluency in it was a form of power that had nothing to do with how loud you were or what your last name meant in Greenwich, Connecticut. I developed a specific interest in estate law, wills, trusts, inheritance structures, the architecture of how wealth passed from one generation to the next, or didn't. I told myself it was practical. I told myself I wanted to help people navigate those systems. Both of those things were true. There was also a third thing I didn't say out loud. I wanted to understand exactly what had been done to me in legal terms, and whether it could have been done differently. Junior year, I took a seminar on trust law. The professor was a former estate attorney from Hartford who had a way of making complex structures feel almost elegant. The way a well-drafted, irrevocable trust, he said, was like a letter written to the future that no one could open early and no one could alter once it was sealed. I wrote that down. A letter written to the future that no one could open early. Sophomore year, I had found a box of my grandfather's things my father had set aside to donate and never gotten around to dropping off. I had asked, quietly, if I could have it, and my father had said fine without looking up from his desk. Inside was a collection of ordinary items, a pocket watch that didn't run, a photograph of Gerald at what looked like a construction site in the 1970s, a few books, a folded piece of stationery in an envelope with my name written on the front in his careful, slanted handwriting. I had opened it alone. It said, "Emily, I have watched you your whole life. You are more capable than this family has made room for. Don't let them set the ceiling. I have done what I can on my end. Be patient. Be steady. The rest will find you. All my love, Grandpa Gerald." I read it 4 times. I put it back in the envelope. I put the envelope in the same zipper pocket as Arthur Wren's notacard. I was 20 years old when I read that letter. I was not ready to call Arthur yet. But I kept his number, and I kept the letter, and I kept studying, and I kept building, one careful year at a time, the version of myself that my grandfather had apparently always expected me to become. Arthur Wren's office was on the 3rd floor of a narrow brick building on Chapel Street in New Haven. 2 blocks from the law school, in the kind of building that had been there long enough that the elevator was original and the hallway smelled like old paper and steam heat. I finally called him on a Tuesday morning in October, 13 years after that first phone call. I was 32 years old. I had spent those years building something my parents would not have predicted and would not have understood. I had finished my undergraduate degree, worked 2 years at a mid-sized firm in Hartford doing paralegal work while I saved, then put myself through a dual program, JD and CPA, that took 4 years and cost me almost everything I had and gave me back something I couldn't have purchased any other way. I understood money and I understood the law that governed it, and I had spent the last 3 years running a small but precise practice in New Haven that specialized in estate planning for families who wanted to do it right. I had built it myself. Every client, every referral, every late night reviewing documents at the desk in my apartment with cold coffee, and the particular satisfaction of work that was entirely, undeniably mine. I had not spoken to my parents in 4 years. Colton had attempted contact twice, once when my father had a minor health scare, once at Christmas, and both times I had responded briefly and without warmth and not followed up. I was not angry, exactly. Anger requires ongoing investment. I had simply moved on, the way you move on from a place you lived that was never quite right for you. Without drama, without ceremony, without looking back more than occasionally, but I had kept Arthur Wren's number. I had transferred it from notacard to phone across 13 years. The way you carry certain things, not because you look at them constantly, but because losing them feels like a different kind of loss. When I finally called, he picked up on the second ring, Miss Parker. He said, and his voice was exactly as I remembered it. Measured, precise, the voice of a man who did not waste words. I wondered if it might be around now. Why now? I asked. Because your grandfather's trust has a specific activation date, he said. Your 32nd birthday was 6 weeks ago. The trust became fully accessible at that point. I've been waiting to hear from you. I was standing at my office window looking out at the New Haven Green, and I sat down slowly in my chair. Tell me, I said. What Arthur told me over the next 40 minutes rearranged the architecture of everything I thought I knew. My grandfather Gerald Parker had come to Arthur Wren in 1999 when I was 8 years old. He had been watching our family for years, Arthur said carefully, and he had formed certain views about how things were likely to unfold. He was a man who had spent decades reading people and reading markets, and both required the same skill: the ability to see not what was in front of you, but what was coming. He had established an irrevocable living trust. Not a testamentary trust. Not something that passed through the will. Not something that Richard and Diane would ever see in probate. Not something subject to the family estate documents that my mother had read aloud over the good china 13 years ago. A living trust, established and funded during Gerald's lifetime, structured outside the Parker family estate entirely, the assets inside it. A commercial property in Fairfield County that Gerald had held separately from the main portfolio, valued at the time of trust creation at approximately $1.1 million. A brokerage account seeded with $800,000, and a parcel of residential land in Greenwich, 3 acres at the corner of Birchwood Lane and Elm Court, that Gerald had purchased privately in 1994 and never disclosed to my father. Over 32 years of appreciation, managed conservatively by Arthur's affiliated investment firm, according to Gerald's written instructions, the total value of the trust at my 32nd birthday was $4.2 million. I did not speak for a moment. He set this up when I was 8, I said. He did, Arthur said. He told me at the time that he wasn't certain what the family would do eventually, but he wanted to make sure that regardless of what happened, you would have something that could not be taken from you. His exact words were, Arthur paused, and I heard the sound of a file being opened. I want it to be the kind of thing that can't be undone by people who might later wish they had thought of it first. I pressed my fingers flat against the surface of my desk. Did my father know? I asked. Gerald told no one, Arthur said. The trust was structured to be entirely private. Your father was not a beneficiary and had no legal standing to be informed. The land parcel in particular was held in the trust's name from the moment of purchase. It has never appeared in Parker family records. There was a pause. Miss Parker, Arthur said. I should mention one additional thing. I became aware recently, through public permit filings, which are a matter of record, that a building permit was issued approximately 4 months ago for the Birchwood and Elm Court parcel. I went very still. A building permit, I said, for a residential structure. The applicant listed is Colton Richard Parker. Another careful pause. I don't know how he obtained access to the land, or whether he is aware of the trust's existence. But I thought you should know before we proceed with the transfer documentation. I thought of Colton's voice note, 13 years ago. Family is family. Maybe you'll come around. I thought of my mother's face over the good china, reading my name off a list like a line item being deleted from a spreadsheet. I thought of my grandfather in that diner booth on Route 1, coffee cup in hand, looking at me over the rim with those calm, unhurried eyes. The things that matter most are never kept where people think to look, Arthur, I said, and my voice was steady. Because I had built it to be steady, I'd like to come in and review the full documentation. Of course, he said. I'll have everything ready. I hung up the phone. I sat at my desk for 3 minutes without moving. Then I opened my laptop, pulled up the public permit database for Greenwich, and typed in the address Birchwood Lane and Elm Court. Permit issued. Applicant, Colton R. Parker. Estimated project value, $1.4 million. Groundbreaking, scheduled on land that had been in my name since I was 8 years old. I closed the laptop. I did not call Colton. I did not call my parents. I did not tell anyone what I had just learned. I picked up my phone and dialed the number of the best real estate litigation attorney I knew personally, a woman named Sandra Okafor, who had an office in Stamford and a reputation for being very calm and very expensive and very effective. Sandra, I said when she picked up, I need an hour of your time this week. I have something I need you to look at. Sandra Okafor reviewed the trust documents in 2 hours and called me back the same evening. She was not a woman who used unnecessary words, which was one of the reasons I trusted her. When she called, she said, Emily, this is clean. This is very clean. Your grandfather's attorney did excellent work. The trust is unambiguous, the chain of title is unbroken, and the Birchwood parcel has been held in trust under your name since 1999. Colton Parker has no legal standing on that land. None. What about the permit? I asked. The permit was issued in error, she said. The county ran a title search that should have flagged the trust, but living trusts held under a separate entity name sometimes slip through if the search isn't thorough. It happens, it doesn't change ownership. It just means there's a mess to clean up. How long to clean it up? Depends on how cooperative the other side is, she said. If they lawyer up and fight it, 6 to 8 months in court. If they don't, much faster. I thought about Colton. His confidence, his certainty, the way he had always moved through the world, as though the floor had been installed specifically to hold him. They'll fight it, I said. Then we'll be ready, Sandra said. I told her to begin preparing the documentation to file a title claim and a cease and desist for unauthorized construction. She said she'd have a draft to me by Friday. I thanked her and hung up and went back to the lease agreement I had been reviewing before all of this. Because there were clients depending on me, and my life did not stop, simply because my family had, once again, made things complicated. That was a Wednesday. On Friday morning, before Sandra's draft arrived, my mother called. I saw her name on the screen, Diane Parker. The contact I had never deleted and never called, and I let it ring once, twice, 3 times, and then I picked up because I had learned, in the practice of law and the practice of living, that it was always better to know what was coming than to avoid it. Emily. Her voice was the same. Composed, pleasant on the surface, with the particular undertone of a woman who had decided in advance how the conversation would go. I'm glad you answered. Your father and I have been meaning to reach out. Hello, Diane, I said. I had started using her first name sometime in my mid-20s. She had never acknowledged it. We wanted to let you know that Colton has a very exciting project underway, she said. He's building on a piece of land out in Greenwich, a beautiful property. We thought you might want to know. As family, I waited. He's put a great deal of his own money into it, she continued. It's going to be a substantial home. He and Alyssa are planning to start a family. That sounds like a significant investment, I said. It is. Which is why, and here her voice shifted, just slightly, the pleasant surface thinning, in the way it always did when she was arriving at the actual point. We wanted to ask if you might be willing to sign a quitclaim deed, just to formalize things. The title company flagged something minor, an old trust document, likely just a filing error from years ago, and it would simplify things enormously if you would sign. I let the silence sit for a moment. A quitclaim deed, I said. It's a standard document. Your father's attorney says it's entirely routine. It would just confirm that you have no claim to the property, which of course you don't, and allow Colton to proceed without any further delays. Of course you don't. She said it the way she said everything, with the absolute confidence of a woman who had spent 63 years arranging the world to confirm what she already believed. I'll have to look into it, I said. There's really nothing to look into, she said. And now the pleasantness was almost gone. It's a simple signature, Emily. Colton has contractors scheduled. There are timelines involved. I don't think it's too much to ask. I was standing at my kitchen counter with my coffee cup, and I set it down very carefully on the tile. I'll be in touch, I said. I ended the call. I did not call her back that day. I did not call her back the following week. I forwarded Sandra the summary of the conversation, and Sandra said, "Good. Don't sign anything. Don't say anything." I said I had no intention of doing either. What I did instead was go to Arthur Wren's office in New Haven and spend an afternoon going through the complete trust documentation, every page, every schedule, every exhibit, with the focused attention I had spent 13 years training. The trust was, as Sandra had said, clean. Gerald had used a firm in New Haven specifically, Arthur told me, because he had not wanted to use any attorney connected to the family's usual advisors in Greenwich. He had been deliberate about the separation. He had thought of everything. There was one clause I read 3 times. It specified that in the event of any unauthorized use of trust assets, including construction, improvement, or encumbrance of the Birchwood parcel, the trustee was authorized to seek immediate injunctive relief and full remediation at the expense of the unauthorized party. Gerald had written his own protection into the document. 3 weeks after my mother's phone call, Colton's attorney sent a formal letter to my office. They had found me through the permit dispute filing Sandra had initiated, demanding that I withdraw what they called my spurious claim to the Birchwood property. The letter was 4 pages long and used words like frivolous and bad faith and referenced my apparent attempt to interfere with a legitimate family real estate matter. I read it twice. I handed it to Sandra. She read it once. They have no case, she said. But they don't know that yet. Or they do, and they're hoping you don't. What do you want to do? I asked. She looked at me over the desk with the calm, unhurried expression of someone who had been doing this for 25 years. I want to let them keep talking, she said. The more they say, the better our record, I nodded. I went back to my office. I went back to my clients. I did not contact Colton or my parents or anyone connected to the Parker family. But every morning that week, I checked the permit database. And every morning the permit was still active. And every morning the construction timeline was still on schedule. And I knew, with the same quiet certainty my grandfather had apparently always had about me, that what was coming was not going to be a surprise to anyone who had been paying attention. The groundbreaking happened on a Saturday in early November. I know because Colton posted photographs on social media, something I had not looked at in years, but Sandra's paralegal monitored as part of the case record. There were 6 photographs. Colton in a hard hat holding a ceremonial shovel. Alyssa beside him in a camel coat, smiling the way people smile when they are performing happiness for an audience. My mother in the background, one hand on my father's arm, the other holding a glass of champagne that caught the late morning light. The land was beautiful. 4.3 acres of old-growth trees and open lawn at the corner of Birchwood and Elm, with a slight natural elevation that would give the finished house a long view across the valley. My grandfather had purchased it quietly in 1994 for $340,000, which had seemed significant at the time, and was now in Greenwich's current market, worth considerably more than the trust's initial projections. I looked at the photographs once. I closed the tab. 12 days later, Colton's attorney escalated. The second letter was different in tone from the first. Less formal, more aggressive, the kind of letter written by someone who had been told to apply pressure rather than make arguments. It alleged that I was engaging in a coordinated effort to damage Colton's financial interests out of personal animosity, stemming from what it called long-standing family grievances. It suggested that my legal filings were retaliatory in nature and requested that I cease all action immediately or face a counterclaim for tortious interference. It also, and this was the part that made Sandra set the letter down and look at the ceiling for a moment, included a paragraph stating that the Parker family had conducted a thorough review of the relevant property history and had confirmed through independent research that no valid trust instrument encumbering the Birchwood parcel exists in the public record. Sandra looked at me. They searched the public record, she said. And didn't find it, I said. Because Gerald filed the trust under the entity name, she said. GHP Family Holdings. Not Parker, not Emily Parker. Not anything that a standard name search would catch. She paused. They don't know what they're dealing with. No, I said. They don't. This was the thing about my grandfather that I had come to understand fully only in the months since Arthur's call. He had not been careless or secretive out of paranoia. He had been precise. Every decision he made in structuring the trust had a reason, and the reason was always the same. He had anticipated resistance, and he had built around it. He had filed under an entity name that required a more thorough search to uncover. He had used a New Haven attorney with no Greenwich connections. He had funded the trust with assets held entirely separately from the Parker family portfolio, so there was no paper trail connecting it to anything Richard or Diane would think to examine. He had even specified in the trust document that Arthur was to make no proactive contact with any Parker family member other than Emily, and only after the activation date. He had, in the most literal sense, hidden it in plain sight. What he had not anticipated, or perhaps had anticipated and simply accepted, was that Colton would try to build on the land before the trust was activated, but he had anticipated that someone might try something. Which was why the remediation clause was in there. I spent those weeks working. My practice was at a stage where I had more clients than hours, which was a good problem, and one I addressed by hiring a second associate, a careful young woman named Priya, who had graduated top of her class from Yale Law and reminded me, in certain ways, of myself at that age. I trained her the way I wished I had been trained, by explaining the reasoning behind every decision, not just the decision itself, in the evenings I ran. 4 miles, 5 on weekends, the same route along the East Rock Ridge that I had been running for 6 years in every weather, because I had found that the body needed something to do when the mind was working on something it couldn't yet resolve. My parents called twice more that month. The first call was from my father. Richard Parker called me on a Tuesday evening, and I answered with the same neutral readiness I had answered every call since this began. His voice was different from my mother's, where she was composed and surface pleasant. He was direct in the way of a man who had spent his career in boardrooms and considered directness a form of authority. "Emily," he said, I need you to understand the situation you're creating. Tell me, I said. Colton has $600. Zuzan and contractor commitments already signed. He has architectural plans, permits, a timeline. What you're doing is going to cost him everything he's put in, and for what? A document from 30 years ago that no one knew existed? Arthur Wren knew it existed, I said. A pause. Who? Grandpa Gerald's notary, I said. He's been administering the trust since 1999. He's been waiting for my 32nd birthday. Another pause. Longer this time. That's not possible, my father said, but his voice had changed. The boardroom's certainty had a crack in it, thin as a hairline. But there, I have the full documentation, I said. Sandra Okafor has copies. The court filing has copies. The Fairfield County land records have copies, as of last month. My father was quiet for 4 seconds. I counted. We'll fight this, he said. That's your right, I said. I hung up. That second call was from Colton himself, and it came late on a Friday night, which told me something about his state of mind. Colton had always been a man who operated in daylight, visible, confident, performing. Late Friday calls were not his register. He didn't start with pleasantness or argument. He started with something I hadn't expected, Emily. He said, "Come on." That was it. Just that. Come on. As though 13 years had not happened. As though Thanksgiving with the good china was something we could simply decide to set aside. As though the word "come on" was a key that would open a door I had quietly, carefully, permanently closed. "I don't have anything to say to you right now, Colton," I said. "You're going to destroy the family over a piece of land." "I'm not destroying anything," I said. I'm standing in a place I was put before you decided to build on it. You didn't even know it existed until this year." "That's true," I said. "But it existed anyway." He was quiet for a moment. "What do you want?" he said. "Money? Is that what this is? Because we can talk about—" "Good night, Colton," I said. I put the phone face down on my nightstand. I lay in the dark and I thought about my grandfather in that diner on Route 1, 30 years ago, letting me talk without interrupting, ordering black coffee and pie, and watching me with those patient, unhurried eyes. I thought about what it must have taken. The foresight, the patience, the love, to build something that would take 32 years to arrive, and trust that the person it was meant for would still be standing when it did. I was still standing. Sandra filed the petition for injunctive relief the following Monday morning. The hearing was scheduled for a Thursday morning in December in a courtroom on the 4th floor of the Stamford Superior Court building. Sandra had requested an emergency injunction to halt all construction activity on the Birchwood parcel pending resolution of the title dispute. The standard for emergency injunctive relief is specific. You have to demonstrate likelihood of success on the merits, irreparable harm if the injunction isn't granted, and a balance of equities in your favor. Sandra had told me, sitting across from me in her office the week before, that she had rarely seen a cleaner case for all three. "They're actively building on land that isn't theirs," she said. "Every day the construction continues, the harm compounds. And our merits case is airtight." She paused. "The only question is whether they know that yet." I thought about Colton's attorney's letters. The confidence in them, the aggression, the absolute certainty that I was on the wrong side of this. "They don't," I said. We arrived early. Sandra and I, Arthur Wren, who had agreed to appear as a witness to authenticate the trust documentation, and Priya, who sat in the row behind us taking notes in the precise, comprehensive way I had come to rely on. Colton arrived with 2 attorneys, which surprised me slightly. The lead was a man named Jeffrey Marsh, a Greenwich litigator I recognized by reputation, expensive, aggressive, accustomed to winning through volume and force rather than precision. The second was younger, clearly there to manage documents. Behind them came my parents. I had not seen Richard and Diane Parker in 4 years. My mother looked the same. Same posture, same composed expression, same way of entering a room as though she had been invited specifically. My father had aged more than I expected. His hair was fully white now, and he moved with such slight deliberateness that hadn't been there before. He saw me across the room and held my gaze for 2 seconds, and then looked away. Colton did not look at me at all. He was dressed well, as he always was, dark suit, no tie, the kind of studied casualness that cost money. He sat beside Jeffrey Marsh and bent his head to listen to something the attorney said and nodded, and from where I sat, he looked exactly like a man who believed he was about to win. The judge was a woman named the Honorable Patricia Ewan, who had been on the Stamford bench for 11 years and had, according to Sandra, a reputation for being extraordinarily thorough and extraordinarily impatient with attorneys who wasted her time. She did not waste time. She opened by asking Sandra to summarize the basis for the injunction request. Sandra spoke for 7 minutes, clear and precise, laying out the trust instrument, the chain of title, the date of establishment, the activation clause, the unauthorized permit filing, and the current status of construction. She referenced exhibit numbers as she went. Judge Yoon made notes without looking up. Then she looked at Jeffrey Marsh. Counsel, she said, what is the defendant's position on the existence of the trust? Marsh stood. He was tall, silver-haired, practiced in the way of men who had stood in many courtrooms. Your Honor, our position is that the document in question has not been verified as a valid trust instrument. We have conducted a thorough title search of the subject property and found no encumbrance consistent with the plaintiff's claim. We believe the filing is. Mr. Marsh, Judge Yoon said, have you reviewed Plaintiff's Exhibit 3? A brief pause. We've reviewed the documents submitted by Plaintiff's counsel. Yes, then you've seen the GHP Family Holdings entity registration in the state of Connecticut, filed in 1999. Another pause. Shorter but audible. We have, Your Honor, and you've seen the trust instrument itself, signed by Gerald Harold Parker. Notarized and dated March 14, 1999, with the Birchwood parcel listed as a Schedule A asset. We've seen the document. Your Honor, we question its. On what grounds? Marsh recalibrated. I watched him do it, the slight shift in posture, the recalculation. On the grounds that the document was not disclosed during the probate of Gerald Parker's estate in 2010, it wouldn't be, Judge Yoon said without inflection. It's a living trust. It doesn't pass through probate. That's what the purpose of a living trust. Are you telling me you weren't aware of that distinction, Mr. Marsh? The courtroom was very quiet. Colton, I noticed, had gone still beside his attorney. Marsh recovered. He made several more arguments over the next 20 minutes. That the trust's activation terms were ambiguous, that the construction had been undertaken in good faith, that the plaintiff had delayed unreasonably in asserting her rights. Sandra addressed each one in sequence, briefly and completely. Arthur Wren was called to authenticate the original trust document and the contemporaneous correspondence with Gerald Parker. He did so in the unhurried, precise voice of a man who had been waiting 13 years to say these things in a room where they would be officially recorded. When Sandra finished her closing argument for the injunction, Judge Yoon looked at her notes for 30 seconds. Then she looked up. The trust instrument is valid, she said. The chain of title is unbroken. GHP Family Holdings, of which Emily Parker is the sole beneficiary, has held title to the Birchwood parcel continuously since 1999. The construction permit was issued in error, as the title search did not capture the trust entity. All construction activity on the parcel is hereby enjoined, effective immediately, pending full resolution of the title matter. She looked at Colton's table. Counsel, your client is ordered to cease all construction activity on the subject parcel by close of business today. Any violation of this order will be treated as contempt. The question of remediation costs will be addressed at the full hearing, currently scheduled for. She consulted her calendar. February 14th. She closed the folder. We're adjourned. The sound of the gavel was very clean in the quiet room. I did not look at Colton immediately. I looked at Sandra, who was already gathering her files with the composed efficiency of someone whose work had gone exactly as she had prepared for it to go. She caught my eye and gave a single small nod. Then I looked across the room. Colton was sitting very still. His hands were flat on the table in front of him, and his face had the particular quality of a man encountering, for the first time, a wall he had not known was there. Jeffrey Marsh was speaking to him in a low voice. Colton was not responding. My mother had her hand pressed to her mouth. My father was looking at the floor. Arthur Wren appeared at my elbow. He was 81 years old, and he was wearing a dark gray suit, and he looked, in that moment, like a man who had kept a promise and could now put it down. Your grandfather would be very pleased, he said quietly. I looked at him. He knew this day might come, Arthur said. He told me once, this was back in 2001 or so. We had lunch to review the trust records, he said. Arthur, I don't know exactly what they'll try, but I know they'll try something, and I know Emily will be ready. I did not say anything for a moment. Outside the courtroom windows, the December sky was a flat pale gray, the kind of sky that comes before snow. He was right, I said. The Greenwich Annual Charity Gala happened every year on the second Saturday of February, in the grand ballroom of the Meridian Club on Mason Street. I had attended it as a child, standing beside my mother in patent leather shoes that pinched, watching her work the room with the practiced fluency of someone for whom social navigation was both skill and sport. The gala raised money for three local causes: the Children's Hospital, the Land Conservancy, and the Arts Foundation. And it was, in the way of these things, less about the causes than about who attended and how they were seen attending. The Parkers had been fixtures at the Meridian Gala for 20 years. My father sat on the advisory committee. My mother had chaired the decorating subcommittee for a stretch in the mid-2000s. Their table was always near the front, always populated with the right people, always a performance of the family they had spent decades constructing. I had not attended since I was 17. I received the invitation in January, 3 weeks after the Stamford hearing. It came by mail, on the Meridian Club's cream letterhead, addressed to Emily Parker-esque. Inside was the standard formal invitation and, clipped to it, a handwritten note from a woman named Catherine Harlow, who chaired the gala's fundraising committee and whom I had met twice at estate planning events in Fairfield County over the past 2 years. The note said, "Emily, we would be so honored to have you join us this year. Your firm's contribution has been extraordinary, and the board very much hopes you will allow us to recognize it in person. Please do say yes." I set the invitation on my desk and looked at it for a while. My firm had made a significant charitable contribution in December. $200,000 split between the Children's Hospital and the Land Conservancy, the first major gift I had made since the trust assets became accessible. I had done it quietly, through the foundation structure Arthur had helped me establish, and I had not expected it to generate this kind of attention this quickly. I called Catherine Harlow the following morning. "Emily," she said warmly, "I'm so glad you called. I hope you'll say yes. You would be our largest individual donor this year, and we would love to celebrate that." "I'll be there," I said. I did not call my parents to tell them. I did not tell anyone, in fact. I went to work. I prepared for the February remediation hearing. I trained Priya on 2 new client matters, and I ran my 4 miles in the January cold. And I did not think about the gala more than occasionally, in the way you don't think too much about something you've already decided. Sandra called me the week before to update me on the remediation case. Colton's contractors had ceased work the day of the injunction as ordered. The site assessment had been completed. The foundation work, already done, represented approximately $380,000 in completed construction. Under the trust's remediation clause, Colton was liable for the full cost of restoring the parcel to its pre-construction condition, plus legal fees. Jeffrey Marsh had made 2 settlement overtures in January, both of which Sandra had declined on my instruction. We were going to the full hearing. "He's in trouble," Sandra said, not unkindly. "I know," I said. "Your parents know the numbers now." Their attorney disclosed them in the settlement discussions. How did they respond? A pause. "Your mother asked if there was any way to restructure it as a family matter." Outside the courts, I thought about the good china, the cream-colored envelope. "Emily has been removed from the document." "There isn't," I said. The night of the gala I wore a dress I had bought in New Haven, deep green silk, simple cut, the kind of dress that doesn't announce itself. I drove myself to Greenwich and parked 2 blocks from the Meridian Club and walked through the February cold with my coat over my arm and my heels on the wet pavement, and I felt, with each step, the particular clarity of a person who has spent a long time preparing for something and is now simply walking toward it. The ballroom was full when I arrived. 200 people, perhaps more, in the formal arrangement of round tables with white linens and low centerpieces, and the murmur of a crowd that had dressed up and was enjoying the performance of having dressed up. A string quartet near the entrance. Waitstaff moving through with champagne flutes. Catherine Harlow found me within 3 minutes and took my hand warmly and introduced me to the board chair and 2 committee members, and I shook hands and made the expected conversation and accepted a glass of sparkling water and felt the room in the peripheral way I had learned to feel rooms. Not looking for anything in particular, simply aware. I was aware of my parents' table before I consciously located it. It was, as always, near the front. My father in his dark suit, my mother in burgundy, her hair precisely done, Colton and Alyssa to their right. 3 other couples I half recognized from years ago. They were in conversation, animated on the surface, and my mother was the last to see me. When she did, she went very still. She said something to my father. He looked up. His eyes found me across the room, and he looked away again almost immediately. The way you look away from something that has caught you unprepared. Colton saw me a moment later. He did not look away. He watched me with an expression I could not read from that distance. Not quite anger, not quite fear, something in between that had no clean name. I looked back at him steadily, and then turned back to Catherine. Dinner was served. I was seated at a table near the front with other major donors, a retired surgeon, a woman who ran a land trust in Westport, two couples from the arts community. The conversation was warm and easy, and I was present in it, genuinely, because these were people doing work that mattered, and I found I had things to say to them. Between the main course and dessert, Catherine Harlow approached the podium. She thanked the committee, the sponsors, the volunteers. She outlined the year's fundraising goals. She began acknowledging the evening's major contributors. My parents' table, I noticed without looking directly at it, had gone quiet. Our largest individual contribution this year, Catherine said, and her voice carried clearly across the ballroom, comes from someone who grew up right here in Greenwich. She is an attorney and estate planner based in New Haven, and she has made a gift that will have a meaningful impact on both the Children's Hospital and the Land Conservancy for years to come. Please join me in welcoming Emily Parker. The room turned, not all at once. It moved in the way these things move, table by table, the ripple of 200 people redirecting their attention toward a single point. Applause began and built, and the string quartet played a soft chord, and the lights near the entrance were warm, and I stood, and I smiled, and I walked to the podium, and I shook Catherine Harlow's hand, and I turned to face the room. I did not look for my parents' table immediately. I thanked the committee. I said a few words about the Land Conservancy's work. I said that some places deserve to be protected, that what is put into the earth in one generation can take root and grow in ways that aren't visible for a very long time, and that it was important to tend to those things carefully. I said that my grandfather had taught me that. Then I looked at my parents' table. My mother was sitting with her champagne glass in her hand, and her face was the color of the white linens. And she was not drinking, and she was not speaking, and she was looking at me with an expression I had never seen on her before. Not anger, not composure, not the managed pleasantness of a woman who had spent decades performing the right emotion at the right moment. She looked, for the first time in my memory, like she did not know what to do. My father's jaw was set. He was looking at the centerpiece. Colton was looking at me, and I looked back at him, from the podium of the room he had grown up, believing belonged to his family, in front of 200 people who now knew my name, and I held his gaze for exactly long enough. Then I thanked the room again, and stepped back from the podium, and returned to my table, and finished my dinner. The remediation hearing was on Valentine's Day. Sandra had noted the date with dry amusement when it was scheduled. Appropriate, she said, given what's about to happen to them. I had smiled and said nothing, and gone back to the case file, which I had read so many times by then that I could have recited the exhibit list from memory. The February 14th hearing was not an emergency session like the December injunction. It was a full evidentiary hearing, which meant both sides presented their complete cases, witnesses were examined, and Judge Ewan would issue a formal ruling on title and remediation costs. Jeffrey Marsh had filed a motion in January to have the trust instrument invalidated on the grounds of alleged procedural irregularities in its 1999 establishment, a motion Sandra had described as a long shot dressed up in expensive language. Judge Yoon had allowed it to be heard, which was standard, and which did not concern either of us. What concerned me, going in, was not the legal case. The legal case was, as Sandra had said from the beginning, clean. What concerned me was the human cost of what was about to happen in that room, and whether I was at peace with it. I had asked myself that question seriously, in the way I tried to ask myself serious questions, not to arrive at a comfortable answer, but to arrive at an honest one. I had spent 13 years building a life that had nothing to do with the Parkers. I had not sought this. I had not engineered it. I had simply answered a phone call and read the documents and done what the law and the facts and my grandfather's careful, loving foresight required. The answer, when I found it, was quiet and simple. Yes, I was at peace with it. Not because I wanted to hurt anyone, because what had been placed in my care deserved to be defended, and because allowing it to be taken by people who had already taken enough was not a form of grace. It was a form of surrender, and I was done surrendering. I wore a charcoal gray suit to the hearing. Sandra wore navy. We arrived early as before with Arthur and Priya and a banker's box of organized exhibits. The Parker side arrived with Jeffrey Marsh and the junior attorney, and, this time, A third person I didn't recognize, a trust expert they had retained to challenge the validity of the 1999 instrument. My parents came again, Colton came, and he looked different from December. The constructed ease was gone. He looked like a man who had spent 2 months running calculations and not liking the results. Alyssa was not there. I noticed that. I did not remark on it. Judge Yoon opened the session and went directly to the motion to invalidate the trust. She had clearly read every filing with care. Her questions were precise and already informed, the questions of someone who had done her work before entering the room. Marsh presented his trust expert, a man from Hartford, who testified for 40 minutes about alleged technical deficiencies in the 1999 instrument. Sandra cross-examined him for 25 minutes. She was methodical and patient, and by the end the expert had conceded that the instrument met all statutory requirements under Connecticut trust law as it existed in 1999, that the alleged deficiencies were matters of drafting style rather than legal effect, and that in his professional opinion, a court would likely find the trust valid. He said this while being cross-examined by Sandra, under oath, with the court reporter recording every word. Geoffrey Marsh did not visibly react. He had been in courtrooms long enough to know how to hold his face. But his junior attorney wrote something on a notepad and underlined it twice. Judge Yoon denied the motion to invalidate. She did it without ceremony, reading her ruling from a 2-page document she had clearly prepared in advance. The trust was valid. The chain of title was unbroken. The property had been legally held by GHP Family Holdings, Emily Parker, sole beneficiary, since March 1999. The construction permit had been issued in error. The injunction remained in effect. Then she turned to remediation. The site assessment Sandra had commissioned established the scope of completed construction. Foundation poured, framing begun on one wing, utilities roughed in. Total value of completed work, $382,000. Restoration of the parcel to pre-construction condition, foundation removal, grading, replanting. Estimated at an additional $94,000. Total remediation liability, $476,000. Plus plaintiff's legal fees, which Sandra submitted at $67,000. Marsh made his final argument for mitigation, that Colton had acted in good faith, that the permit had been validly issued, that the burden was disproportionate. Sandra addressed each point. Judge Yoon listened with the focused attention she brought to everything, and when Marsh finished, she looked at her notes and then looked at Colton's table. "Mr. Parker," she said. Colton looked up. It was the first time she had addressed him directly. "You obtained a construction permit for this parcel without conducting a title search, adequate to identify the encumbering trust," she said. "You proceeded to construction without confirming clear title. You received a cease and desist letter and a legal filing from plaintiff's counsel prior to breaking ground and proceeded anyway." She paused. "You are a sophisticated party undertaking a $1.4 million construction project. The standard of care required of a sophisticated party is not met by relying on an incomplete permit process. Mitigation is not warranted." She looked back at her document. Total remediation award to plaintiff, $543,000, inclusive of legal fees. Colton Richard Parker is ordered to cease all further activity on the Birchwood parcel, fund full remediation within 90 days, and pay plaintiff's awarded fees within 30 days of today's date. Title to the parcel is confirmed in Emily Parker as sole beneficiary of the GHP Family Holdings Trust. We are adjourned. The gavel came down. What happened next happened in the compressed, strange way that consequential moments happen, too much at once, with a quality of unreality that only settles into meaning later. Colton put both hands flat on the table. He sat there with his hands on the table and his head slightly bowed, and he was very still for a long moment, long enough that Geoffrey Marsh put a hand on his arm. My father stood up abruptly, and his chair scraped back, and the sound was sharp in the sudden quiet of the clearing room. He stood there for a moment, one hand on the back of the chair, and he looked across the room at me with an expression I had not seen on his face before. Not anger, not authority, the things I was accustomed to from him. Something older and smaller than those things. My mother's champagne was water today. She had it in her hand and she set it down on the table, and her hand was shaking slightly, and she pressed both hands into her lap. She looked at me. I looked back at her. I did not feel triumph in that moment. I want to be precise about that, because I think it matters. I felt the specific weight of something long unresolved becoming resolved. Not light, not celebratory, but solid. The feeling of a door that had been left open for 13 years. Finally, quietly, closing, Sandra touched my elbow. Ready? Yes, I said. We gathered our files. Arthur walked beside me toward the exit, steady and unhurried as always. Priya held the door. Behind me I heard my mother's voice, not directed at me, directed at my father, low and tight in a way her voice almost never was. I did not hear the words. I did not need to. Outside the courthouse, the February air was cold and clean, and the sky was the pale blue of a winter afternoon that might, if you were lucky, hold until dark. Arthur stopped on the steps beside me. He was breathing a little harder from the stairs, and he adjusted his scarf and looked out at the parking lot with the calm expression of a man who had seen many things conclude. "It's done," he said. "It is," I said. He nodded once. "Gerald would have found the Valentine's Day timing amusing," he said. He had a sense of humor about these things. I looked at him. He did, I said, and for the first time in the long months since his call in October, I felt something ease in my chest that I hadn't fully realized was tight. 6 months after the February hearing, the Birchwood parcel was restored. The remediation company Sandra had recommended worked through March and April, removing the foundation, grading the land back to its original contour, replanting the disturbed areas with native species the Land Conservancy helped me select. I visited twice during the process, standing at the edge of the site in my coat, watching the machinery work, and both times I felt the same thing. Not satisfaction exactly, but something closer to rightness. The land had been here before any of us and would be here after, and what had briefly been imposed on it was being undone carefully, one layer at a time. By May, the parcel looked almost as it had in the photographs from Gerald's 1994 purchase. Open lawn, rising toward the tree line, the old-growth maples along the eastern edge undisturbed, the natural elevation that gave a long view across the Greenwich Valley, unmarred by anything man-made. I had decided by then what I was going to do with it. Nothing, for now. I was going to leave it alone. I had arranged with the Land Conservancy to maintain a stewardship agreement on the property. They would manage the meadow grass, tend the tree line, keep it as it was. I paid the annual taxes without resentment. I had no plans to build and no plans to sell. My grandfather had bought it because he thought it was worth preserving. I agreed with him. Colton paid the remediation award in 2 installments. The first in March, the second in late April, just within the 90-day window. I learned this through Sandra, not through any direct contact. The legal fees he paid within the 30-day deadline, which, suggested his attorney, had advised him firmly on the consequences of contempt. I learned other things through the ordinary channels of a small world. Greenwich is not a large community at the level my family occupied it, and information moves through those channels with the particular efficiency of places where everyone knows everyone and pretends not to notice what they know. I learned that the $543 Zeros and Zero Remediation Award, combined with the contractor commitments Colton had already paid before the injunction, had effectively exhausted the liquid assets he had accumulated. He had funded the project using a combination of savings and a construction loan, and the loan's terms had become complicated when the injunction halted the project. He had spent 4 months in negotiations with the lender and ultimately sold his house in Cos Cob to settle the balance. He and Alyssa had separated in March. I had not sought that information. It came to me the way things come to you when you live in proximity to a world you grew up in, through a mutual contact, mentioned without apparent awareness of its relevance to me, in the context of something else entirely. I received it, and I set it aside, and I did not dwell on it, because Colton's marriage was not something I had caused and not something I was responsible for. My parents lost their position on the Meridian Club's advisory committee in the spring. The circumstances were not made public, but the timing was not ambiguous. My father resigned, according to the brief item in the local newsletter that Priya mentioned seeing, to spend more time on personal matters. My mother's name disappeared from the gala committee, listing I received in the mail in June. I thought about what it cost them. Not the money, which my father still had enough of, but the position, the standing, the carefully maintained performance of the family that had it figured out. That was the currency my parents had spent their lives accumulating, and it was not something you could reconstruct quickly once it began to dissolve. I did not feel satisfaction about it. I want to be clear about that again, because I think clarity on points is important. What had happened to my parents was the consequence of their own choices, the choice to cut me out, the choice to allow Colton to proceed without due diligence, the choice to fight rather than to call me. and have an honest conversation at any point in the 13 months since Arthur's first letter had surfaced in the legal proceedings. None of it had been done to them. It had been done by them. Arthur Wren retired in April. He sent me a letter on his firm's letterhead, formal, precise, characteristically economical with words, informing me that he was closing his practice and that all trust records had been transferred to my firm's custody as per the trust instrument's administrative provisions. He thanked me for my patience over the years. He said it had been an honor to fulfill Gerald's instructions. He said he hoped I would take good care of the land. With the letter was a photograph I had never seen. It was black and white, slightly faded at the edges, taken in what looked like the parking lot of the Route 1 diner. Gerald's diner. The one my mother had considered beneath the family. Gerald was standing beside a car, maybe 60 years old in the photograph, and beside him, holding his hand and squinting into the sun, was a girl of about 8 in a puffy winter coat, me. I was 8 in the photograph. I didn't remember it being taken. On the back, in Gerald's careful slanted handwriting, Emily at the diner. She always ordered the grilled cheese. She never finished it. She was too busy talking. GP, January 2000. I sat at my desk with the photograph in my hands for a long time. Then I put it in a frame and set it on the corner of my desk, where I could see it from my chair. My practice grew steadily through the spring and summer. I took on 2 additional clients in April, both referrals from the Land Conservancy connection, and by June I had brought on a second associate to work alongside Priya. I moved to a larger office space on Chapel Street, 3 rooms, a small conference room, a waiting area with a window that looked out over the green. I furnished it simply and well, the way I did things. I thought about my grandfather often in those months. Not with grief, which had softened over the years into something quieter, but with a kind of conversation. The ongoing internal dialogue you have with people who have shaped you, even after they are no longer there to respond. I thought about what he had seen in me when I was 8 years old, sitting across from him in a diner booth, talking too much to finish my grilled cheese, and what had made him decide, in his careful, deliberate way, to build something that would take 32 years to arrive. I thought he must have understood something I was only beginning to fully understand myself. That love, real love, the kind that actually changes things, is not a feeling, it is a decision. It is a set of actions taken quietly, over time, without guarantee of acknowledgement, in the direction of someone you believe in. He had believed in me before I had learned to believe in myself. In July, I drove out to the Birchwood parcel on a Sunday afternoon. I parked on the road and walked out to the center of the open lawn and stood there in the summer light with the maples along the eastern edge, throwing long shadows and the valley visible below and the sky very blue above. The land was still and full of small sounds. Insects, a bird somewhere in the tree line, the distant sound of a lawnmower 2 properties over. I stood there for a while. I thought about the girl in the photograph, squinting into the January sun in her puffy coat, holding her grandfather's hand. I thought about the woman I had become, standing on ground that had always been hers, that no one had ever truly managed to take, in a life that was entirely, undeniably her own. I did not cry. I stayed until the shadows lengthened and the air cooled, and the first suggestion of evening came across the valley, and then I walked back to my car and drove home. Here is what I want you to take from this, if you take anything at all. The people who dismiss you are not telling you the truth about your value. They are telling you the truth about their limitations, what they cannot see, what they cannot hold, what they have decided, for reasons of their own, not to acknowledge. What they decide about you does not determine what you are, what you build in the years after they decide. The quiet, steady, patient work of becoming yourself on your own terms. That is the thing that lasts. My grandfather knew that. He knew it about himself and he saw it in me, and he did what he could to give me time to find it. I found it. And if you are watching this today, and someone in your life has tried to tell you what you are worth, and their answer was not enough, I want you to keep going. Not for them. Not to prove anything to them. For the version of yourself that is still being built, one careful year at a time. Keep going. If this story stayed with you, leave a comment below and tell me why. Tell me where you are watching from. If you have ever been written off by someone who should have believed in you, I want to hear about it. Like this video if you believe that quiet people can move the loudest mountains. And subscribe, because there are more stories to tell.